Alrighty, this is just We the People News, one more time at it. Alrighty, so a while back I seen this video, but I got busy doing other things. And as you notice, it's been a good couple of days since I've done a video doing research and all that kind of stuff. Right? Because even though he gives good information, you also got to go back and reread everything to kind of start understanding the pictures that he's describing. Um, you know, because really, if you sit and think about it, still right now, right? Uh, this is a Southern drawl law, okay, and I like him, but he's still hearsay to me. We got to do the research, people, okay, and it's nothing better than actually going back and read something and focus to see if it does contend with what he says or anybody else says. Until then, it's hearsay. I'm hearsay. Okay? Judge is hearsay. And to be honest, Judge gets things wrong all the time, like Terry versus Ohio. That's absolutely a wrong ruling. And Pennsylvania, Pennsylvania, Pennsylvania versus Mims is a wrong ruling. All right? It's taking freedom and not giving freedom. It's been a one-sided ruling. All right? And founding fathers gave them a permission to amend the Constitution, but order when we was more established is to give us more freedom, not to take more freedom. So all the judges, all the attorneys, and all that has been, and government obviously is being misimplied the interpretation of fathers because they've always wanted less government, never more government. So why would they give them the right to amend the Constitution to give them more authority? Right? Sit and think about this. Uh, is to restrict them more, not give them more. All right. Um, I'm not an attorney, not giving legal advice. Anything I say or do is just my opinion only. All right. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. All right. You guys know how I feel about attorneys, so you can always still learn from attorneys as well. Okay. And I don't know him from Adam. I just know he does good videos, and again, I think outside the box. So if I'm going to learn something, sometimes it's good to go to an attorney like him. And you want to at least fairly understand and trust what they're talking about to actually use them and all that kind of stuff. Because there is, well, the whole state of Texas is full of crap attorneys and full of crap judges. All right, they've been violating the criminal codes 14, 15, and 16. And by the way, in 16, the magistrate has got 48 hours to issue a writ. Okay? And if there's in Texas code, if he doesn't do it in 48 hours, the case is dropped automatically and you cannot come back to it. But our prosecutor's been lying to everybody. Our judge has been lying to everybody. And everybody in the state of Texas, as judges and attorneys and all that, needs to be impeached. My rant and rape right now. All right. I don't know about Tennessee. Tennessee's got a good constitution, and Texas has got fairly good constitutions. Um, too many. So, but everybody needs to learn the most important part of the Constitution. Texas, Article 1, 15. Okay? Texas, Article 1, 16. 15 is to impeach these darn judges that cause you harm, loss, and damages. And you go to that legislature and use your First Amendment to petition your regress and your monstrance unto them and give them an order to start impeaching these darn judges that's acting in dishonor with dirty hands and bad faith. Sorry, y'all. All right, so he's actually going to point out 6 elements of the Terry stop. Okay, and write these down. Pause it. Write it down. Okay.
you guys think? So we know from the opinion in Terry that in order to do a justifiable frisk, we first have to have a constitutional stop. But more than that, in addition to a constitutional stop, we need the officer to have a reason to believe that the person being detained is both armed and dangerous in order to justify a Terry frisk. And again, the court defined a Terry frisk in the actual holding of the opinion, where it said that we merely hold today that where a police officer observes unusual conduct which leads him reasonably to conclude in light of his experience that criminal activity may be afoot, and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. So again, let's break that down into the elemental requirements, okay? So
now, even in Terry, there's a conflict in the Constitution or from the judges, right? Because they also tell the cops that they have no duty to protect you. In fact, recent federal judge said it's okay to shoot innocent people to get the criminal. I mean, you can't make these stupid things up. This is how corrupt our judges and all of them are, right? This Terry says that, for the officer's safety and for the public. And then turn around and says that there is no duty to protect you. And then, in fact, later on, that you're allowed to shoot innocent people to get to the criminal. I mean, never mind.
Number one, you got reasonable articulable suspicion that criminal activity may be afoot. Number two, a reasonable belief that the person may be armed and presently dangerous. Number three, he must identify himself as a police officer. Number four, he's supposed to make reasonable inquiries. Number five, in the process of doing his reasonable inquiries and investigation, nothing in the initial stage dispels his reasonable fear for his own safety or others' safety. And number six, when all of these things are true, then the officer can conduct a pat-down limited to the outer clothing to discover weapons. As an aside,
now, he'll go into a couple other deals, and if you want to check out his whole video, get over there. You're going to learn some things, really good stuff, okay? And again, me giving him this deal, I got to like him in some aspect, okay? So, but the issue we have today, right, is the pat down for dangerous weapons. Now, my understanding with dangerous weapons, they don't get to reach in my pocket because of my car keys. Okay? That's after I'm arrested, not before. They don't get to reach in there because I have money in there. The pat down is for weapons that cause harm, damage, and loss to others and to the officer's safety. That's all that pat down is. Knives, swords, and all that kind of stuff. And I dare to say it. Okay? A little baggy, the funny stuff. Well, no. You get that after you're arrested, not during the Terry. You know what I mean? So, you guys sit and think about this. I may be wrong. I'm not an attorney. I'm not giving legal advice. This is educational purpose only. Yakety yak, 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 yak. But this is the way I look at it. The whole purpose is officer safety and the public. Well, my lighter has nothing to do with the public safety or the officer safety. The key has no authorization to dig in my pocket. My money and dare I say it, some type of pipe for, how would I put that? Partying time. All right. It's not danger to the public or to the officer. They don't need to reach inside your pocket. Okay. Now you'll have to fight that in court, obviously. But It seems reasonable to me if it's just for officer safety.
And that, just like with Detective McFadden, an officer doesn't have to see a gun or a bulge or anything like that. It can just be a reasonable or rational inference based on the same information used to justify the detention. So just like Detective McFadden articulated that he thought Terry and Chilton and Katz were planning a robbery, the rational inference is that if they were planning a robbery, they might have had guns. And if they had guns, the rational inference meant that they were a danger to him if he chose to interact with them. And that's how the court arrived at a reasonable belief that they were armed and dangerous. Again, armed.
Yeah, and there we go again. The video circulating with uh, Mason out there, Madison. Okay. Due to hearsay, talking about weapons gave an officer concern that there may be a carry. Okay. So it gives them a officer safety product. But if somebody's kind of like, forgot to turn their blinkers on and all that kind of stuff, well, really and truly, if there's nobody around you, there is no public safety or officer safety. So they don't need to get in there and pick your pockets just because, So, again, not attorney, not giving legal advice. But this is Diesel with People News. There's your 6 things that you keep an eye on and bounce it back. All right. And write it down and keep it handy when you are in your car. Till next time. Bye, y'all.